long day. From 100 something people who were left 20, 25. It's good. At least we have the speakers here. That's a heroic achievement, I think. Now the roundtable discussions are called roundtable here not because the tables are round. Okay, so it's a conceptualization. It's the idea of a roundtable and not the roundtable itself. Okay, because someone asked me and complained that the tables were not round with the roundtable. Don't complain about that. Now the message is we invite people from different countries. Usually they are all seniors, but we make exceptions to the rule. And what we are trying to do is to say something about education and research, that's all. And that closes the first day usually of the conference. So it's not a recognition of your past achievements, and it's not a first step to the future achievement. It's just to share ideas, and people that they are coming from different countries, maybe they have something to say about education and research in the field of law. Of course, last is our research fellow. I asked him and he kindly accepted. Is here somewhere or he's smoking down? Yeah, I know. And so Georgios Zoulakis, he will be the last to say a few things about the Greek legal system and practice. So I'm not going to take more time. Actually, I'm moderating. That means I'm going to shut up, and I'll keep only the time, which will be less than 10 minutes. So less than 10 minutes. If you cannot do it in less than 10 minutes, then I remember what I written. Nobody writes. Nobody reads what I write, but I follow what I write. So Mark, I'm not going to try to pronounce the name. I mean, you can do better than me. So, I mean, I can say my name. So he's all these things, and he's first, and he's going to talk, I guess, about South Africa.
Yeah.
Okay, good. You have 9 minutes to impress the world, sir.
I'll try to do it in 5 if I can.
Between 5 and 10 is good. Less than 5.
Thank you very much.
You're welcome.
Don't know why the nerves is striking me now, so yeah. Good afternoon, everyone. My name is Mark Velgemuth. I am the Head of Department of Criminal and Procedural Law at Nelson Mandela University in Port Elizabeth, or Gqeberha as it's known now, in South Africa. And I chose tonight to talk about an exciting new project that we have at our law clinic. And something that's unique to our university and our law clinic in South Africa in context of the future of law, education, research, as well as practice. Now, the project that we have, I must first acknowledge, did not come from us. It came from our previous dean in collaboration with quite a big law firm in South Africa. They sat together in 2019 and they actually evaluated what is going on at our law clinic. And I don't know how many of you are involved in law clinics, or I'm sure you all have law clinics at your university. Our law clinic is very much paper-based. So everything is in paper-based files, everything is done on paper, there's a paper-based diary, and they said, you know, we are in the firm grip of the 4th Industrial Revolution. We must embrace the technological advances. We must embrace what it can offer to us, not only as far as access to justice is concerned, but also as far as education for students are concerned. So let's devise a system that can basically make the law clinic paperless. Now obviously, you can never get a paperless system, there will always be paper. I always say digital systems increase paperwork for me because I must improve on everything. But anyway, we, in collaboration with this big law firm, Cliff Decker Hofmeyr, we came up with a system called Hive Law. Now what Hive Law basically is, it is a cloud-based client management and case file system. So client details are now entered online, in a cloud, in an electronic database. Their documents are uploaded, IDs, so on. Everything is in electronic format. It is in the cloud, as I said, so it is quite safe, it is secure. And so gone are the, well, I can't say gone are the days, but it's a much more secure system than not finding an entry in a paper-based diary because it was not written in, or a page was torn out, or it was written on a little note and put somewhere. You know how it goes when we all get busy. So the system actually offers more than that. It offers document generating software where staff and students who work on the system can basically now pull up a template of a legal letter, enter information like client information, who the specific consultant or attorney is, and everything will appear on the letter. You just type the content. And the same goes for legal documents. It has report generating capabilities. So you can see who your clients are, from what denomination they are, male and female, what type of case, how many divorces do you do, how many domestic violence matters are you doing in a year. So basically it also has a feature called Intap, which links up with Outlook. So when you send an email in Outlook, it provides an additional prompt which asks you to import a case number. So you can import your client, your case file number there. When you send an email, it takes the email and immediately puts it in the electronic client folder. So gone are the days where someone, for example, leave your offices and you can't find the emails they've been working on. I'm sure everyone has struggled with that somewhere in your life. So for us at the Law Clinic, this will change lives, definitely of the staff and students. Work can be done quicker, more secure. Everything will be at one place. When you look for it, with a click of a button, you can see the status of the case you're working on. And that's as far as access to justice is concerned. As far as student education is concerned, we try to adapt to the paradigm of constructivism when we work with our students. We try to not feed them information. They must work on something and get experience for themselves so they can experiment with the system. In fact, now in a week's time, we start lectures on the 22nd. It will be the first time that they will experience the system. So we foresee that they will get experience in working on electronic database systems in law firms, which will prepare them for the world out there. So it's a whole new work integrated learning experience for them. The system has evaluation and assessment capabilities. So we can now, when students do work, like for example, write letters on a client file, send it to us, we can evaluate it, we can assess it, we can send it back for queries, and so we can even give them marks for that on the system. At the end of the semester or the year, we can generate a mark for them. So I didn't want to go too much over my time, so
you covered the 5 minutes that we promised.
Yes. So I'm going to conclude and say that we look very much forward to see what the system can do. As I said, we are the only university in South Africa who will have the system. No one else has. And I know from a conference I've spoken at in January, other universities are already lining up to know, but when can we get our hands on this? I have no answers to that. But that is what we are doing at the moment to enhance the future of education and practice at our university. Thanks, ladies.
Thank you very much for taking your time. I think I need a microphone because I'm
Interesting.
we don't have my place still. What do you expect from these barbarians when they come here? Okay, our next, thank you very much, Mark. We get it 6 minutes, excellent. So you set the pace for the next one, not the challenge, between 5 and 10. Our next speaker, the most important thing that comes from Spain. Spain? Not here.
He's here.
Okay, congratulations yesterday that you got the European Cup. Even though I don't like the team because they don't take they don't have
That's why we won, yes.
Yeah, that's why you won. The most important thing is to win. If you win, that's what we remember. Thank you very much for accepting my invitation. We have 9 minutes to impress the world. Thank you.
Thank you very much. I want to thank Atiner organization for inviting me to take part of this not round table. And as we are in Athens, I have written something, but I want to do this because This is the most innovative thing I can do this afternoon, because Aristotle or Plato or Socrates didn't use any PowerPoint or slides to teach their students when they wanted to transmit some knowledge. And
Turn
that's
off the microphone right away. Turn off.
this
Right
is,
away, turn off the microphone.
this is ancient Athens. I wanted to say something different that I'm going to say now, because I was thinking this morning about what the most important things I would like to transmit this evening. And first of all, most of the people think that the new technologies are the better way to transmit specialized knowledge, as it is the case of law. But the real thing is that this is being a real failure, at least in the classroom. I will divide my intervention in three parts. What we do in the classroom, the lecture room, what we do outside the classroom in research, and what we do in the practice of law. By the way, I am the director of the Law Innovation Center, but we don't innovate in teaching. We try to innovate in research or in practice of the law. We are very connected with the large Spanish law firm to try to research and to try to have better innovations in the practice of law. In fact, I come from a university that is ranked, I'm not going to be very humble with this, but it is ranked number 1 in Spain in practice, and 13 out of 20 managing partners of the most large Spanish law firms are alumni of our university, so we are very connected with them. What we do in the classroom, as I said before, it is very difficult to transmit specialized knowledge with the new technological tools we have. Of course, it is another way you can use to give some tasks to the students, but it is not the only way, and I prefer the old-fashioned, the old way to transmit, because until they don't know the institution, the general principles of the law, it is very difficult for them to precise when they are using new technologies such as AI or some technological tools that can help you to find out the judiciary or some other things in the case law. So it is important, if they don't know, for instance, the torts theory or the principles of the regulation of the markets, it is difficult for them to find anything. So we are keeping, and we have a very important problem in the classroom, that is the concentration. When they are using computers, when they are using mobile phones, it is very difficult for them to follow the class, because more or less they have 15 or 20 minutes of concentration, and then if you don't prepare the right way the lecture, they go away and they don't follow your explanation. So you have to be very precise in preparing the lessons you are going to give to the students. In second place, what are we doing in research? Research is changing a lot, as you can see. When you are writing a paper, you have almost everything at your fingertips, wherever it is, because with the internet it is very easy to find the papers you need to work, and that it is very helpful for you in your research, in your investigation. And this is transforming our way to do things in that area, in that field. And I think the most important things are happening in the practice of law. In our university, we are a very innovative university, and we are working with the legal publishers and the law firms in the AI tools we have now to find law cases, judiciary and everything. Last week we have a meeting where we are going to buy a new technological tool for our students, but we are prioritizing our postgraduate students, especially our students of the bar master. Those who are about to sit to the bar exam in 1 year's time, so they need these technological tools because it is the tools they are going to have when they practice law in a large corporation. That is one of another characteristic or profile of our students. They are going to the large companies and the large law firms in Spain. That is the average of the situation of our students when they finish the postgraduate programs. That depends on my office as well. So, as I said before, I can know we all know that Immanuel Kant didn't need any technological rule to write his books. Neither Mozart need any technological tool to compose the Requiem, nor Socrates or Aristotle or Plato need anything else that we know that he went the old-fashioned way to transmit their knowledge, and it wasn't bad. About the future, I think we are in a very transforming era. We don't know yet what is going on in the next year, but we can foresee something, and some things I can foresee, I don't like it. But in the practice of law, perhaps those legal firms that are not in a market niche are going to have some serious problems in the future to survive, because you need to add value to your counseling if you want to survive in the practice of the law in the next few years. We are beginning with the AI, but it is, Claudio this morning said, we are about a winter in the AI maybe, but we are starting with the AI. It is difficult to foresee the progression the AI is going to have in the coming years. Maybe we are going to have a winter, but what I foresee now is that we have in a very spring or summer of the AI. It is not something different to your thought, Claudio, because we can discuss that, and I would like to discuss with you about this, but it's going to transform everything in general, and of course, in particular, the practice of law. Only the large companies are adapting their technological rules, and they are spending a lot of money to adapt these tools they have to the practice of law to create value to the client. So there is where I see more changes, but inside the room, in the lecture room, I will go for the old-fashioned way to transmit knowledge, a very special knowledge as the law is. Thank you very much.
Excellent. 9 minutes. Excellent.
9 minutes!
You have the AI in your mind. I mean,
Generally.
it's embedded into your mind, so it's perfect.
Thank you very much, Mr. President.
Yeah. But I have some reservation about what you did, because if you read one of Plato's dialogue with Socrates, one of the guy that he participated, he was reading from a papyrus. So the move that made it very impressive. We took a picture so we can show it to the world that you don't need it. But it was in ancient Athens. They were reading from papyrus.
Tomorrow I'm gonna have some slides. I don't know what I'm going to do.
Okay. Actually, I'm so since we are waiting, I'm so perfect, modestly perfect, that I think I'm the creation of AI. I mean, I'm not myself. we had a roundtable discussion about engineer guys, and they would say about AI a lot. And I say, how do we know that we are not a creature of AI and someone controls us?
It's a no-brainer.
Yeah, I mean, it's a very difficult argument. Okay. Actually, I call it mechanical support. So I don't need mechanical support. I can talk without them. But some people, they need it. Now we have a lady, so we're very lucky. And she's coming long way, or you are already in Europe. Are you already in Europe now?
Yes, I am already.
I know you are. Yeah,
I'm sorry to disturb, but I think I forgot my papers somewhere.
I took them.
Okay.
We have a slave here. We have a slave here.
Yes.
Okay.
No back.
Since the reason that we chose here has nothing to do with anything else but the country. So we don't have people from Latin America. Actually, it's the second or last week we had another presentation. And next room we have someone from Peru. Because we try to bring people together. Okay, 9 minutes to impress the world, lady, including Latin America.
Thank you very much. I will present the importance of rereading the classics in law schools, taking the case of William Shakespeare. I am Francisca Renditz. I am lawyer at an international law firm, and I am professor of law and literature at the Pontificia Universidad Católica de Chile. I will structure my presentation in the following way. The law and literature movement, the idea that art shows life, the question about why William Shakespeare, the law in Shakespeare, and why we read Shakespeare today. The law and literature movement is an academic movement that emerged in the United States in the 1980s. It examines the relationship between these two disciplines from an academic perspective. Traditionally, it has proposed that these two disciplines relate in 3 ways: law as literature, other forms of relationship, and law in literature where we stand. Law in literature proposes that literature shows the main dilemmas of the philosophy of law, allowing us to reflect. But where does this idea that art shows and imitates life and therefore law comes from? More than 2,000 years ago, Aristotle wrote the Poetics, where he proposed that art is imitation of human nature, understanding human nature as human behavior. This concept of imitation developed over time, finding a significant expression in the Elizabethan era and particularly in William Shakespeare. In the English Renaissance, the concepts of theatre as a mirror and theatrum mundi were widely known. Theatrum mundi meant that the stage was a scene of the world, a place to learn. The design of the theatre was circular, precisely as the world, suggesting that theatre shows the world. Why Shakespeare? According to Samuel Johnson, Shakespeare imitates essential human nature, which is universal, not social. According to Harold Bloom, Shakespeare is the center of the Western canon because it is present in all time and spaces, only comparable to the Bible. Therefore, he shows life in all its dimensions. Shakespeare, through his character Hamlet, says that the purpose of theatre should be to hold up the mirror of the nature. Here we find Hamlet, always tormented by his doubts about whether to be or not to be, and Falstaff, always cheerful with a beer. In this way, Shakespeare shows life and love as a part of life. For example, in his biggest tragedy, Macbeth, he shows the physical, social, and psychological damages of tyranny. These allow us to reflect about power and the rule of law. As we know, the main characteristic of the rule of law is to protect fundamental rights, such as freedom. In his comedy, The Merchant of Venice, he shows how the literal application of a contract can lead to an injustice, appealing to mercy, allowing us to reflect on law, values, and principles. Then, why rereading Shakespeare and the classics today? Because Shakespeare shows us the main dilemmas of philosophy of law, allowing us to reflect. But in a deeper way, universalism is out of fashion today. And Shakespeare shows us what we have in common as human beings. And we need that union to address the current problems, such as the reunification of Europe and the first unification of Latin America, the climate crisis, migration, demographic issues, and especially, and above all, the suffering of war. Harold Bloom says that the ultimate use of Shakespeare is to teach us to think very well about what we must and without perishing. Last year, I proposed to the law faculty to create a course of law and literature. In this course, we examine how masterpieces of world literature show the principal dilemmas of law, allowing us to reflect. We study two key movements of Western literature, that is to say, Greek and Elizabethan. We read in groups, and the final exam was a debate in the moot court room. The course was well received by the students, all the spots were filled, and it has been scheduled for the coming years. There are the students preparing for the debate, and the moot courtroom where the debate was held. Thank you.
You're welcome. Closing, you tied together with the scene of the round table. Our next speaker is from Padua, Italy. Did you come here by boat or by plane?
By plane.
You know, in the 1970s, even Germans, they were coming, they didn't know how they would come. They were driving, they went to Bari, Argona, and
Take the boat.
yeah, people laugh, but they don't know how.
How difficult. You sit down to write and say that.
Now the boats are very, I have done that, it's excellent. Now they say it's very convenient.
I tried.
Okay, 9 minutes.
Okay, thank you very much. My talk is about the future of legal education between humanities and technology, so it is the beginning of our conversation about technology and law. And traditionally, in Italy at least, a solid classical education was considered essential to pursuing a law degree. And despite the changes in society and university organization, the belief that classical culture is beneficial for jurists persisted until recently. However, this idea is now disputed. The modern view questions whether legal education should still be found on humanistic studies or on a more adequate scientific preparation in order to partner the broader technological revolution. On the other hand, since technology is radically transforming our way of life, also the scientific and technological academia is more and more aware of the need for a general understanding of the legal issues gravitating around any attempt of innovation, thus welcoming interdisciplinary efforts in research as well in education. Apparently, our comfort zones are currently shaking. Scientists and jurists need to find common ground to dialogue, and this has educative implication, of course. But in order to find this common ground, we need to pinpoint in how many ways the information communication technology impact onto the legal experience. And as difficult as it is this enterprise, I try to make a kind of general scheme showing in a simplified but hopefully complete manner the different ways in which they have impacted the ICT upon law. I identify at least 5 ways, and each of these in turn is synthetic of numerous dynamics involving transformation in society and in the conceptual tool used to understand and order them. The first and perhaps most trivial profile of impact has to do with the transformation, availability, and management of legal information. Historically, this has been the first form of applying information technology to law through the establishment of legal databases back in the 60s, and the consequent increase in the automated information retrieval facilities. This transformation has profoundly affected the very method of constructing legal discourse, in particular the way in which lawyers and judges search for the premises of their arguments, leading some scholars to talk about the emergence of a new methodological field called digital topics. Digitalization of legal information, transformed it into data, then has been spread around the internet, retrieval through digital platforms, and now it is used to feed the AI, to create robotic assistants able not only to retrieve information but also to create the legal content. In rhetorical terms, we can call this evolution from digital topics to automated eloquence. Understanding properly the nature and functioning of such astonishing tools requires a kind of education that is still not usual to find in the regular curriculum of law students. Strictly connected to this last observation is the second way in which ICT are impacting upon law, which is by determining, this trivial, even this one of course, determining the needs of changes in the content of regulation. By this expression I refer as much to modification in the compartment of regulatory texts, as well to changes in interpretation, especially by judges, aimed at adapting already existing texts to new conflicting cases involving technology. This leads to another point, which is the need for a broadening basic knowledge in legal training. The regulation of areas characterized by high technological incidence determines an important phenomenon of linguistic transformation of normative text, which consequent criticality in the activities in the interpretative communities called upon to stabilize legal concept and make them available to the community. In fact, the latter are mostly composed by scholars and practitioners not specifically trained in the science and the technological application, whose lexicons are introduced into the legal text. This situation, when referred to the judicial activity of applying such regulation, has suggested the doctrine, the interesting expression of opaque norms, or you can call the general phenomenon, call it regulatory opacity. The magnitude of the information that is when a text incorporates some technical terms coming from different areas of knowledge in which the judge is not trained. So it has to rely to another subject, which is the expert, to apply the law. And this is normative opacity. The magnitude of the information technology revolution has made this phenomenon almost ubiquitous in the legal system, resulting in the need to broaden the range of legal interpretative communities to include stable forms of dialogue with those of technicians, scientists, and professionals in the field involved. But the issue is far more complex, since the characteristic feature of high specialization is precisely that it is inversely proportional to the number of subjects who share it with adequate competence. The higher the specialization, the fewer the subjects that master that specific knowledge. All this leads us to consider the focal point of normative opacity. The phenomenon calls into question the very commensurability of the communitative practice involved and the subject knowledge that are part of the communities in dialogue. Okay. This is a quite complex point. A more specific way in which ICTs affect the legal experience is manifested then in situations in which the transformation affects what I call, lacking of a better expression, the semantics of praxeological terms. In a sense, a certain legal institution remains unchanged in its name and effect, but the concrete behaviors required to realize it in the world are radically changed. In fact, a completely different practice takes the form of the concretization of that certain legal requirement. This change is holistic, meaning that the way in which people structure their behavior to comply influences also a complex of other non-compliant practices. In other words, existentially, technical legal compliance requires the structuring of new forms of life because of technology. This is usually seen as an improvement, and this is usually said that it is doing the same thing but in a more efficient way, but this is a lie. This is always a lie. Not because it is not efficient, but because it's not the same. It's not the same listening MP3 or listening to a vinyl or listening to a live concert. These are completely different forms of life. That's why electronic books sell exactly the same as paper books, and they live together in the market because are different forms of life. It is a lie that it is the same thing but better. Finally, the social transformation in which the IT revolution is embodied produces significant modification in the ethical experience and the understanding of the moral dynamics of the community. With reference to this point, we register an interesting phenomenon. As ethical concerns about the use of technology are becoming a staple point in all discussion of the fourth revolution, jurists are often required to deal with this along with a specific legal compliance. This is because in these cases the word ethics is used in the sense of that Luciano Floridi called soft and post-compliance ethics, some kind of an ethics that fill the gaps of legal regulation. This is exactly the approach used by the ethics guideline for the Transport AI. As we see, there are many educational implications that we may draw from this articulation of the impact of the ICT on law, but I would like to conclude by hinting at a more profound point if I have a couple of minutes more.
Couple.
Couple.
You have 3 minutes.
Thank you very much.
And you are cheating us because per minute you speak a lot of words. In other words, you speak fast.
The general scheme I just proposed has presupposition. The legal experience is made real by complex of various communicative practices, and so is education. Communication is made possible by the human intimate inner subjective symbolic capacity. Humans are highly evolved symbolic animals. Now the technological revolution of our age is exactly the current result of a continuous symbolic engineering human has gone into since they developed awareness of the power of physical science to convey meaning in a high variety of ways. Symbolic engineering involves bodily movement, oral sign, that is language in its immediate form, and then different forms of signs used through abstraction. Writing is another one. Plato used technology, the technology of writing. Homero used technology, technology of oral speaking. That was symbolic engineering. In 1982, Walter J. Young, a seminal work, Orality and Literacy, formalized the distinction between primary orality, literacy, and secondary orality. In 1992, wrote the amazing intuition that electronic computer-mediated communication were producing a secondary orality, that is the resurgence of some traits of oral culture in a still fully literate world. Now, if Ong and others, for instance, Eric Havelock, for instance, are right, this is going to have an impact on what we are, of the same importance of the changing from morality to literacy. But we can still see exactly what it may consist in. Tertiary orality is a way to begin to pose this problem. Law is strictly connecting our Western mind to literacy. So the advent of the tertiary orality may produce transformation so deep that we could have difficulties even to recognize it anymore.
Thank you very much.
Welcome back.
Okay, our next speaker has the advantage that I can pronounce his name, Ilias Kostas Grigogiannis, correct?
Correct.
And he's from United States, Greek origin. And he's going to talk about efficiency as well.
I have some training in law, but my focus is economics. I teach economics at Yeshiva University, Jewish University, New York, which is the largest private Jewish university. It has a mission to prepare leaders for the Jewish communities around the world. Most of our economic majors, they end up getting a law degree or a medical degree, after graduation. In the United States, the law degree is a graduate degree. But that means you cannot study law before you finish 4 years in an undergraduate program. So in the undergraduate program, we have to prepare the pre-law students for the law schools.
The same applies to Canada as well. Because I
That's
was in
true.
Canada, yeah.
That's
Canada,
true.
the same thing.
Yeah.
I had many students in economics that they were doing law. I wrote a lot of
Exactly.
letters of recommendation.
As a result of that need to prepare our economic majors for the law profession, during my tenure at this institution, I developed 3 courses to prepare those students. One course on economics and the law, which is broadly taught around the world. Also, I developed a course on forensic economics with focus on assessment of economic damages, which is of important value to U.S. attorneys, because before they take a case, it is important for them to assess the value of the case, because in most cases they have to consider taking the case on contingency. What that means is they don't receive a penny from the plaintiff unless they earn a penny for the plaintiff. And usually their fee is a percentage, usually 33% of the money they will earn in litigation for their client. So all law firms, they have to know before taking a case whether or not it will pay to spend the time to defend the case. If the case doesn't worth their time, they will ask to get paid by the hour. So, unfortunately, in no place around the world there is a place where people can acquire academic training in what we call forensic economics, or the technique of learning how to assess damages. In most cases, damages are easy to assess. You get a car from a car dealer, and on your way out, someone hits you and destroys your car. What's the damage? You replace the car. What if you lost your leg? Well, then it's not that straight. The insurance will pay for your leg, but how much? Someone has to monetize the value of the lost leg. In some cases, you have no idea where to start. Have a case of a divorce, where a young lady stands in front of a judge claiming, "Your Honor, I was a happy young lady before getting married to this gentleman. During the last 5 years of my life, this gentleman made my life miserable."
You point to the right person.
By accident. By accident. The way he was treating me made me so depressed. I lost my ability to enjoy life, and he should pay for it. Now,
But
the
she
judge-
has 3 lovers.
Yeah.
One for Monday, one for Wednesday, one for Saturday. She enjoyed life with my money.
Well, the judge said,
Fantastic.
well, this young lady has a valid claim. She lost something important. She was able to be happy with herself and the world around her, and because of the way this gentleman was treating her, she became so depressed, she lost her ability to enjoy life, and she's asking me to make him pay for it. Where should I start? I'm the judge. You know, What can I do with my attorneys? They have no idea where to start. There is only one profession which has developed the methods to deal with that problem, forensic economists. I have been teaching to my students, my pre-law students at Yeshiva University since 2001, a course in forensic economics. And also another course preparing my students for the law school is economic efficiency and justice, which I would like to say a little more about in today's discussion. Always there is a concern on whether or not the institutions we create to satisfy the needs of our broader self. See, we are not only what is contained within our skin, we are broader than that. We are the community, we are the nation, we are the world. And this broader self has broader needs. And the societies, we create social institutions to satisfy those needs. Such institutions are the educational institutions, religious institutions, institutions of justice. And the question here, the concern is how well those institutions play their role or deliver what is expected from them. Do our institutions of justice always deliver justice? If not, why not? Is there anything we are missing that could help repair the damage? What about the religious institutions? Do our religious institutions deliver what people expect from them? Right? Each one of you has an answer. And the same is true also with our educational institutions.
Elia, you have 1 minute.
All right.
You finish?
Now coming to the legal institutions in their role and our expectation to deliver justice, in the course I have developed, I have emphasized the problem of efficiency. Why? Because the problem of efficiency is the problem which have been more seriously and carefully studied and developed by economists over the centuries, over the years. So economists are probably in a better position to understand and come up with some recommendations about efficient outcomes in the human activity than probably other professions. So, well, let me see what then. Let's go to the next. Doesn't move.
Yeah, because you feel the time fixed.
Yeah, I'm trying to make it move because I have just let's see. Oh, it needs to, yeah, it got disconnected. Okay, so yeah, I'm not going to. I will skip this.
The bottom one, to kado.
Try any button, it's gonna work.
Yeah, I will skip that. I will skip that.
You have to skip
Look
everything.
here. Up. Go to the next one. How do I go up?
The other button.
The previous one. Oh, okay, here. Now, let me just give you a sense on how the concept of efficiency can apply to the concept of the expectation of dealing with crime in our society. What's the objection? To reduce crime. Why? Because it makes life easier, better, safer. Now, you ask lawyers, you ask judges, you ask other professionals. to give you recommendations, and they will come up with a plethora of suggestions. You ask an economist. An economist will start, in most cases, with symbolic language. Instead of telling a story using linguistics, plain English, they will give symbols, will summarize a story using a mathematical equation. So, an economist will tell you that if I want to consider dealing with the concept of crime, I will consider crime, I will try to identify, what makes people behave like criminals and how much crime they produce in the process, or what will make them slow down in their speed of producing crime. So, one determining factor is the probability of detection. If I'm committing a crime within 4 walls, no one can see me. It's more easy to give in the temptation of criminal activity.
Ilya, we run out of time. No, I think we have to finish.
Finish.
They know this because it's the school of Chicago. Tell them it's the school of Chicago.
Exactly.
And they know it very well.
So, probability of detection, probability of conviction, and the severity.
These opinions that I will reveal or share with you, only just my opinions without scientific facts, only depends on my own experience. It's like loud thinking, brainstorming. So I am not responsible what I say. I may U-turn, I may defend opposite of the opinions that I say today in the future. So it's just a loud thinking. Then, where we are, exams. Exams functions. Exams serve justice a kind of way. I mean, by exams we reward hardworking students, we say A, and we kind of eliminate this F grade, uninterested and non-working students. So it's have a lot of different functions. In fact, in our practice, what we teach is what we ask. I mean, our students always focusing on exam questions. What will our lecturer will ask at the exams? They try to find it and just focusing on the exams. So the topics of exams is the topics that you make students for their attention to work or study more from other topics to exam topics. So it's really serve as a getting education better and better, and as knowledge and also practice purposes. I mean, what I mean I will explain in further pages. And at this phase I want to say large classes because maybe students, the classes with less than 20 or 30 students, it's really simple. Maybe we may say exams are not necessary because we have direct relation to students, communication. You can value a student in every aspect. Attendance, contribution during lessons, assignments, presentations, blah blah. But with more than 100 people, for example, in our classes we have about 150 students in one class. So we can't directly evaluate every student by one. So we need exams. For us, exams are necessary, but doesn't mean it's the only way to grade students. Of course, we use exams. We may depend on different criteria, but in our practice, in my practice, I do only exams. But I mean exams, of course, quizzes and exams. In a half a year, we sometimes we have some different practices, but in normal conditions we have one quiz and one exam. One quiz is in 2 months, and after 4 months, at the end of the half year, we make an exam. So with 2 tests, we perform a half year and we conduct just 2 exams for our courses. So, of course, we may have different approaches, different methods, but I try to briefly get them together. First, exams medium. I mean, we shall conduct our exams on paper or at computers. For 2 years, we start to conduct our exams at computers. We change paper to computer. I will explain why we choose this, but it works for us for nowadays, for this year's maybe. When we start to use computers, we ask students to take them computers to classrooms. Of course, they usually take their computers to classrooms, and we have also laboratories, so there's no problems computer reaching. So this computer, there is so many different ways to ask a question, but the simplest way is multiply choices, test questions. We start to prefer this kind of questions because we have bar examination. We have justice or minister examinations for being a judge or prosecutor. So in these exams, Turkey is a really big country, population is high, so the exams are trying to eliminate younger students which are hardworking or which are not really hardworking. So we ask, our practice, we ask multiply choice for 60%. We usually ask 20 or 30 questions from a question bank. We have prepared question banks with 200 questions in it, maybe a little more. The software just randomly pick different questions for different students. Every exam is different for another student, so they will know cheating, just focus on their exams. So it works a kind of way for us. But of course we have no opportunity to depend on just multiply choice questions. We are in no possibility. They have to write something on paper or computer. Writing is essential. So
2 minutes.
2 minutes.
okay.
You can use less.
Thank you for this opportunity. So we have 2 more questions. One is essay question. We gave them an imaginary legal problem, not so complicated, a simple problem, and try assign them to solve this problem in their words, in their sentences. And one another question for about 20 points. We want to write them a simple petition, recourse statement on claim or complaint, depending on our subject. So we try to conduct our exams in this formula, in this method. As I said before, I have a disclaimer. I can just behave differently. This is just we conduct our exams these years, and in the future it will be changed. So I want to just share our practice, if possible, to hear your thoughts about it. It's done. Thank you for patience.
Thank you very much. Okay, 2 more, it's over. Our 7th speaker is from France. You want me to read your name? No. Maybe I'll kill it. Gaëtan Balan.
Yeah, perfect. Yeah.
9 minutes. Did I say 9 minutes?
Yeah, 8.
8 minutes, that's good. That's good.
Okay, good evening everyone. I know it's a long day, so I go to the point. Thank you, Mr. President, for your invitation. Thank you, dear colleague. And I will speak to you about utilization of serious game during the legal teaching. And first, dear President, the first step for serious game is to organize a round table. We transform the classroom to organize a round table because around a round table all is equal. You have the same position. So, firstly, when you explain to the student we organize a serious game, you have a first reaction. Yeah, it's cool, we don't work. After, you explain the rules, and the reaction is not the same. Why? Because you have, the first rule is, it's a necessity for you to resume the legal position of all other players, because at the end of the simulation, you will written a statement, and it's a necessity to resume each position of each team with legal basis. So after you explain that, it's a little bit less funny. So how we could organize a serious game? Basically, it's a methodology, but I know it's long, so I don't develop that too much. The important point is to determine your teaching objective. For what reason you use serious game? Because for certain teaching it's adapted and other it's not relevant, just because the course it's not concerned by that. It's a very ongoing teaching experience, because during the session you have a very hard rules for a teacher. You don't have the right to correct the player. You have a time of feedback at the end to correct a major mistake, but you don't intervene during the game. They negotiate all together. Why? Why is that? Because serious game is an exercise of legal qualification of each problem, and you need to use your skills to help people. Basically, I create a serious game. His name is Nice 360, and basically a hurricane arrived on Nice. You need to evacuate all the population. People say, yeah, it's cool, we save people. Yes, cool, but how? It's humanitarian law. Cool, but you don't answer to my question. So for help them, you have an application of the International Red Cross Committee. They can use them. But if you use this application, we don't change the time of response. You have 2 minutes to explain your position and no more.
I like that.
And after, we use the superpower mute. It's end. And at each station, you have new events that arrive. By example, who is concerned by vulnerable people? You have an hospital and a jail to evacuate, or it's easier now. You have 2,000 people in one and 20,000 in the other. It's long. In 2 hours, it's done. No. So you need to, for students, it's interesting because they can experiment stressing situation, and the timekeeper to learn to qualify, to legally qualify the situation. And the objective is simple. My student, by example, go in a crisis room or crisis team. So first time you will be able to work with everyone. You don't choose the team of emergency. So, and after, don't panic. You make to take a decision. It's not bad or wrong. It's just a decision, but decide. Because if you don't decide, you have consequences, and it's another step of the simulation. It's the second, basically. Students need to explain the consequences of choice of the other students. Why? Because we use basically caricatural situation like we can destroy this or something like that. Why? Because it's simpler for students to understand extreme situation, but they are in situations of it's an obligation to find something and to find a way to negotiate with the other. On another simulation, the objective is to negotiate a new space treaty with the exigence of fair trade about resources on the space. So same thing, people say it's simpler, and after the team try to negotiate, you have 2 minutes for explain your position, and it's impossible. Yes, I know, but you have 2 minutes. And after, sincerely, after a few experiments, students, they adapt them. So it's not perfect, yes. But in 2 minutes, they arrive to make a demonstration, to present a position in regard of the element of the steps, because something can change in the other step. So that could evaluate the adaptation capacity. So it's, I think, original approach. It's not new because you have war game in the army, it's a business game in business school, but in law we are not very confident with that. You have two ideas. By example, NIS 360, it's one session of 3 hours. But the negotiation treaty, it's during all the courses, so 30 hours. You have session of negotiation and this session of course, because it's interesting if you heard your teacher to understood what is a treaty, but it's better if you practice. You make mistakes, all in this place, include me, we make mistakes. It's the process of learning. So it's my background about, sorry, this utilization of sales game, and I think I respect the time.
Yes, you have 3 seconds to say thank you very much. Our last speaker is going to talk about the Greek system, since we left it out.
I spoke about it already, and a great day actually. And I'm sure that it would be the same pity if you left without having some, at least, insight on the situation in Greece regarding some pressing topics for practice, for the judiciary, and extended also to legal education. So, now that, without further ado, so that's actually an excerpt from my doctoral thesis, which survived somehow to the publication. So back in 2016, the major issue with the Greek justice system was how quick it is, actually how slow it is, and it remains slow. And the second slowest in the EU, proudly. So, as I wrote then, this law rhythm under which Greek justice operates has been an issue for decades. We have a disproportionality between the numbers of judges and the volumes of litigation, blah blah, but the government thought twitching with the codes of civil process would expedite things. And I politely wrote, no, it wouldn't really. So I just wrote, we should not expect too much of it at a short point in time, nothing. And I'll explain why. So, was I right? Boy, was I. 8 years later, we've got the famous or notorious, depending on the point of view, Vissarioudis report, or otherwise put, where's the slide? Yeah, I think so. All right. Meaning how was it named? Here, growth plan for the Greek economy. So, nothing really changed, and pursuant to this report, trying to pinpoint the issues with the justice system and legal practice in general, we had some statutory, having some trouble with this, figure it out. Yeah, okay, I found it. So we had some statutory intervention. We had very recently, 2 months ago, it came into force, Law 5108 of 2024, which basically tries to square the circle, trying to expedite justice by twitching with the allocation of courts. Let me explain. We have at the preamble that the required efficiency is not achieving courts with less than 15 serving judges, right? Citing there the World Bank, the European Commission for the Efficiency of Justice, etc. To explain, in Greece, we used to have, up until now, the so-called ειρηνοδικία, roughly similarly to magistrate courts. And of course, we had and we still have at least one court of assistance per region, right? 51 regions in Greece, not that. So, in effect, what I thought is that according to this idea spelled out in the preamble, let's merge the magistrate courts with the courts of first instance, abolish completely in that way magistrate courts, bring together the judges from the lower level first instance courts with the higher level first instance courts, right? The aim, the stated aim, of course, is improving the efficiency of civil and criminal justice. We don't need to go through all that for the sake of efficiency. And mostly it's spelled out in case C, the relief of the courts. By that, they try to state that some courts are overloaded, whereas others never have a significant volume of cases. Now, yeah. So basically, they did exactly what the Psaridis report told them to. Okay, if you read this excerpt, and I'm not going to read it out, I just don't want to waste your time, but if you read this excerpt, it mirrors, it reflects 100% what I tried to explain just before. Were the reactions? Quite many. So the board of directors of the Association of Judges and Prosecutors said that splitting the courts of first instance to several units, because that's a problem. If they merge all magistrate courts with the courts of first instance in a place like Athens, that would mean that 20 courts would merge into one. That, even in terms of space, makes no sense, right? So they thought, okay, let's merge the magistrate courts with the court of first instance. However, we will divide the court of first instance into smaller units, mainly in Attica, mainly in Athens and Piraeus. They didn't do it this way. So, judges complained about that. They said, in this way, we restrict access to justice, especially for the poor, who cannot afford to travel in order to have their case heard or their case filed. Bar associations also said splitting the courts of first instance will lead to chaos. We do nothing to expedite justice. There's no infrastructure to support it, neither there will be in the set deadline whereby the transitional period expires, September 2026. Court clerks and personnel said there's no plan as to what will happen with pending cases, where services will operate, etc. The real problem is that there is 35 to 40% deficit in required personnel, so they are understaffed. Surprisingly, this was admitted also by the Psaridis report. So who's wrong? Is the government wrong? Are any of these groups wrong? Well, in my opinion, those groups were all spot on. The merger of courts into a court of resistance and splitting of the big courts of resistance into smaller units will do nothing to expedite justice. At the end of the day, it's quite simple. A judge will be assigned with a number of cases for a certain court date, will go study them, usually at home when it comes to Greece, reach a verdict, publish a verdict, especially for civil cases, right? Of course in criminal justice as well. So, it's simple math. It's basically total workload divided by the total number of judges. So this is the formula, if you like. It's actually a fraction, a simple fraction, whereby you get a good indicator of how fast a justice would you expect as a citizen. So, misleadingly, this report and the government, who references that continuously, they refer to the fact that there are more than enough judges per population. They say that, for instance, in Greece, we have more judges per 100,000 inhabitants compared to Spain, Germany, France, Italy. Okay, which is true. And that's not the correct metric. Again, it's not the population, it's the workload. In Greece we have chief justice, and that's what they don't want to admit. That it's very easy and very cheap for any person to go to court. That's why we have many frivolous litigation. Because it's extremely easy to go to court for nonsensical disputes. So, what's the result of that? Bigger workload. Slower justice. How do we solve this? Well,
George,
the problem, yes.
If you don't finish in 2 minutes, I'll take you to court.
I'm not going to take myself. So if the ratio of case per judge would not be addressed, Greece would continue beating around the bush, basically. There are 2 ways to do it. Either we decrease that. How? By, let's say, making access to justice more expensive. Or we increase that, the number of judges. So both solutions, however, come with serious political cost, especially when the funds are not unlimited. So there are other measures proposed by this report that I mentioned. I don't want to bother you with all that. Returning to my first slide, this report surprisingly said that let's extend those twitches in the procedural codes to other procedures. That's a sensible. I mean, yes, filing all the particulars in advance with a certain deadline after filing the lawsuit gives the possibility to the judge to review them quickly if they're assigned with a case immediately. That's not the case, however, that's a problem. Yes, we filed a lawsuit here, right? We filed the particulars within 4 months' time. When will the judge take the case in their hands? After a year. When will the court date be set? After 2 years. So it's pointless. No, and just, I think I have 30 seconds, right? So other problems, educational and training quality. I mean, even according to the EU, we're quite good, both as regards our judges, but also the practitioners. The problem is that the pronounced problem is of specialization. And that, when it comes to practitioners, that's their business, right? If they want to attract customers, to give good services, up to them. However, when it comes to judges, that's more of a state concern. And nothing has been done, and nothing can be done if they are overloaded with cases. And the biggest problem with this, I conclude, is not digital justice. By that, don't think of anything matrix-like or intricate or sophisticated. No, I'm talking about the basics. I'm talking about the ability to file particulars remotely. I'm talking about having the ability to stand in the court remotely. We don't have that yet. Even filing a lawsuit is possible in certain procedures. So, no wonder why things are a bit slow. Bottom line, all require this money and some investment in justice in order for it to get faster. Trying to twitch with procedural codes or moving people from one building to the other won't do much. Thank you for your attention, and
Now, before I open up the floor, I'd like to ask Professor David Fregel if you want to address the issue or any other. You want to come here, or we can have the microphone. David?
Okay. Well, you give me a hand that I can stand. Okay. Thank you. Well, I heard a lot of philosophy, a lot of practice, but when I look at the item, which is the future of legal education, research, and practice, not the way, not which kind of education. What education? You see, you speak legal education as though it is everybody knows what is legal education. I don't know what is legal education. That's not how many judges will be and how will the classes will big classes, small classes, exams. That's a practice. And of course, I would say the problem is not the legal education. The problem is the future of education. The law is a part of education. And we have no education, I'm afraid. We don't know what education means. And then we say the research and practice. You can't have, I don't know, how can you teach practice without knowing the meaning of education? And the research today, we all know that the research of the students is Wikipedia. It's not a research anymore. The research is Wikipedia. And the future is how many judges will be, how many courts will be, how many cases will be judged. That's not the future of legal education. It is maybe the future of legal practice, but it's not education and no research.
Thank you very much, David. David has been, for those that are new, he has been very instrumental in setting up the unit. He edited a lot of books that are outside, and now we published from the Athens Journal of Law, and he's doing an excellent job along with my daughter. You collaborate very well, David, with my daughter. So I use nepotism so she can work with him. And actually, because of that, she's doing now a postgraduate degree at Toronto in using artificial intelligence. And so she's going to help us further. But anyway, enough. Do you really want to say something? That's the question. If you want really to say something useful, say it.
Sounds like that's too much pressure already.
Yeah, but then it shows that you have something to say.
It's useful.
Yeah, make sure that you don't say it for them. But nobody. Say it. Come on. You want to say something?
Yes, but I don't know if...
Oh, you say it. Don't worry about what I'm saying.
questions and comments.
But don't ask questions the other because we're not gonna finish. But you say your own position. That's what I like. Say
Okay,
what
yeah.
you believe.
So I have a comment.
Not to the others. Say it as a comment to all the audience.
Yes. Very interesting presentation. Actually, I'd like to respond to Professor Frankel about the relevant comment about, like you asked, that actually you said that we should ask ourselves what is legal education, what do we consider to be legal education?
Can you identify yourself?
So it should be education first, and then
Yes, yes, and what is, legal practice as well. Karine Miller, I'm a professor of constitutional law at the University of Montreal. And one of my mandates has been to develop a compulsory course on indigenous legal traditions. So this is where I'm going with my comment, because I think that one of the major aspects of the future of legal education, to think about what is law, what is education, what is legal practice, would be also about decolonization, which doesn't mean to reject what we consider in the colonial world to be the law, the state law, and legal practice and education, but also to revitalize the indigenous legal practices that more and more, for example, we consider in Canada to be also valid legal traditions, so to be as valid as civil law and common law traditions. And so this is something that we see, this change regarding the content of what we teach itself as being like the grounds of law, but also it's changed the legal practice because we see more and more indigenous courts going in Canada. So really we're going to another level, I'd say, towards a third level of government. And it also changed the way we teach very slowly, very slowly. But in this compulsory class to all the law students, and the majority of them would be future lawyers, we try to really teach in circles. So you said that there was enough round table here, but we try to transform the classroom. And actually we split the big auditorium into small circles. And we try to teach and like more in a different way. So coming back to old ways of doing things. But that was just my short point.
Anybody else?
Education is something more than law. Don't you think education is broader term than law?
Absolutely. It's broader than law, but it's also about like how you define law. So my comment was about, revitalizing and seeing law from a more pluralistic perspective. But true, more and more we should integrate like social sciences. We thought that we had this economics and law perspective, but I think more and more, well in Canada we're going towards more courses integrating other disciplines, philosophy, social sciences, and see like more broadly the normativity instead of being like very separate as it used to be. I think it used to be like very separate, a chasse gardée, like legal education. And now, I have only one French colleague who understands.
Is it education or teaching?
That's a good question.
Is it education or just teaching?
Well, I would say both.
What do you mean by education? What to teach, or how to teach, and what will be the meaning of teaching?
Yeah.
Should it be everything? Or now as we go all over the world, everybody who got his matriculation becomes a lawyer.
Yeah.
I think it's absurd.
I have a word, David.
In order to become a medical student, got a lot of examinations to see what your personality is. When you go to study law, 1800 and the American marks, yes, no, and that's enough. That's not education.
Yeah, true.
Okay, we have 3 more so far that they want to register their presence here for their team so they can justify the funds that they got. Identify yourself because we're going to put you as an interventionist.
Oh.
Costas is doing that.
Yes.
Your name will appear in the program. Good.
Professor Montana Makani from the University of Fort in South Africa. I'm a professor of Eastern the area as well as in constitutional law and human rights. My bit is just to share what I've heard from the First Nations, that we are sharing common problems. whether we are in the south or we're in the north. Because it's starting with the quality of education that we provide, it is a critical concern as to what is it that we put into our curriculum so that we produce the kind of a student or the kind of a graduate that will have the attributes that will contribute to the development of the law in our area. And one other thing as well is the quality of assessments or of marking the assessments related to the large classes. Because we have 400, 600 in a class. We are teaching 2 modules, like in my case, teaching 2 modules. We have 5 days to mark 400 students. So the way in which now we have to assess the quality of the work that we were expecting the student to give it back to you. Those are one of the things that affect even the feedback that we provide to the students. And even the judiciary itself, we have common problems: infrastructure, capacity, huge workload, and the judges have to produce judgments within 3 months after having had this much of the cases that we presented before them. So that is why Prof. Horace was asking whether legal institutions as well would they actually deliver justice, because it touches on the challenges that we are faced with. In terms of how we address them, it depends on the financial muscle of the state. That to pump money into institutions of higher learning, to put money into courts, to put money in all the areas. Because in South Africa, we are still fighting as well.
You're still fighting?
Yes, we're still fighting in South Africa. We're still fighting about blackness and whiteness. As to who must be appointed as a judge, whether it's a woman, it's black, or it's a man, and so forth. So that is where we are. Because when it comes to judicial appointments, there's a white flag. Whether that particular candidate, despite the merit that person has,
Okay.
the color will come, the race will come, the gender will come, the everything will come.
But the United States is the same. We are fighting over the same thing. We have another lady that she wants to register her presence for the intern.
My name is Yana Reshova. I'm coming from Prague, Charles University Law School. And, Law School. Charles
Country, the country.
Czech Republic. Prague. And so I haven't prepared any paper for this debate, but I don't know. I don't need to record it.
Just a photo.
No. Minutes. Yeah. So as for the education, I think what makes sense in any university, any school is just not to cheat. Not to cheat in any exams, any multiple choice, any Moodle platform. So I think this is the part of the education. Irrespective whether it's legal, but in legal education it makes more sense than probably in the others. This relates to the thesis, to the diploma certificate, because my experience is that students, majority of the students want to become lawyers, and as quickly as possible, and using methods that offer the easiest way to get the certificate or the diploma. So this is by just one point. Second, what about what's the role of the teacher? Just or what is to be in the CV? I would very much agree CV as material to read. I think today's students don't want to read many texts. They don't want to read. So, for instance, I teach the course of theory of law, Georg Jelinek and the others, and we have the Aristotle's constitutions, for instance, and the purpose of reading the selected text is to make them aware that from the history there are some patterns of behavior that are not similar, that are not the same, but they can be compared. And for them it's too, you know, too broad, too distant from today's society, and they don't want to read, and then I'm not saying in general terms, but the majority of them are not willing to invest into the broader, let's say, broader view on the world as it was and it is now. It's, I think that this is the shortcomings of the contemporary university education.
Just to make a note, because of course that's what we are doing in the round table. We put the names of the people that they interview. Okay, so if you don't want, I mean,
no, I don't protest, but
because it's important that they see other people your intervention. But in any case, that's up to you.
It's not necessary for me to intervene anyway. I've been professor of law in Ljubljana University, Slovenia, all my life. And one thing I wanted to communicate to you in relation to new technologies. What I observe is that legal education has changed to legal gathering of information, not to education. The human interaction in education, which is essential, connected probably with some dislike of large texts, which is probably the result of all the technologies available to young people from the start. The result is a bad mastering of language. The result is that they do not seek knowledge, but seek fast access to information. And my view, that is very bad. The direction of legal education. In the last result, it shows in dropping of attendance of lectures. Basically, their interaction with teachers, with lecturers is lesser, more superficial, and but I may be old, I'm maybe not very
I like this word may.
Yeah. Great.
I can use it for myself. I mean, you are so right, so I'll tell you, because I have the privilege in attending many small events in all fields. The similar was raised, I'm not supposed to talk, but similar was raised in literature. A lot of people say now, the publishers, they don't like novels that is more than 60 pages. So, and we have the deputy head of our literacy, she's from Poland, Alexandra, she has this Polish name, I found easy for me, Terinienga. And we have the CA here right away, here is Poland. And she published 2 novels so far, and there are 300 pages, say, you know, and say, it's for children. So very beautiful, both of them. Okay, I don't want to. You want to say something? Okay, I'll come to you.
Thank you. Noelle Hunter, University of Alabama in Huntsville. Thank you for all of the presenters. I'm struck by the need for us to be looking inwardly as well as teachers, to my colleagues' point. So I'm a social scientist, and I wholeheartedly agree with integrating the social sciences into legal education curriculum. But I'm also wondering, are we as teachers, as professors, adapting to the changing environment, that we're having the same expectations for our students? And so I'll use my case in particular. I'm a political scientist, and I'm teaching the presidency this fall, and I cannot teach it in kind of the foundational ways in which it has always been taught just in our field, just because of how the presidency has evolved, how it's incredibly dynamic and problematic and out of balance with the institutions. And so how am I as a teacher, and how do we as colleagues adapt to the changing environment that students don't want to read. I don't know if it's all true, but it's true for mine. And so how do we make ourselves better beyond conferences, which are great for learning and engaging, but the times that we're in require a significant adaptation of our pedagogy and the way that engages with our students.
Okay, anybody else that feels they will need to you present it here. Yeah, you want second time. And one thing you want two interventions.
Yes, that because of what you from your name?
Me, Yana.
Yana, what you were saying, that I think that the posture of Lucio Ordine about why we reading classics, Lucio Ordine, a philosopher, and he has this methodology in the university. He started making this. During all Mondays, he just chose a little piece of any classic. For example, you mentioned Jelinek. A little piece of Jelinek. Little piece. 5 lines of Jelinek. And just students went to the class and they read the 5 lines of Jelinek and say anything they want. And what happened was that the class began to get full of people. So he says that one possibility is to start choosing little pieces of masterpieces and to convince students to read them complete. And I think that in the course I give in university, I do that. All the classic works, I just choose only little pieces and we read them together, and they only have to read one whole piece because they will not read everything.
Okay, I think we should stop here because we have 15 minutes to walk to the Greek night, which is a terrible thing, by the way. It's a modern Greek, you will see the degeneration of the kind after 2005 years. So you compare tomorrow night, that when I prepare the Athenian ancient dinner, and tell me which one is different. And, so you have a company. Here we call modern tonight is the modern Athenian way of entertaining yourself. It's a matter of pedagogy. And tomorrow night, including the food and the discussion, I'll prepare mine. So this is you compare modernity with the ancient time, and I'm not kidding. You will see it tomorrow. The recipes are over there. There was someone from Latin America about the beans, and he says they are from Latin America. And then I have all the references there. He doesn't listen. But I want to say something. Everybody used the word reading. When I was a high school student, 2 things about the textbook. You know what they're doing in the Greek high school system? They have problem with the textbook. So they give little textbooks every term. So the students have to, so they fool the students, in other words. They have 3 or 4 textbooks over the same subject, but they are small. And they put pictures in, which I hate, of course. In math, we put pictures and story. But when I was young, and what I did, we have this tape recorder, because I like to listen, not read. So I was tape recording all my books. So when I was sleeping, then I put that because you can hear walking, but you cannot read, because I was hyperactive. So I could listen my own voice. And that was, it's called hypnopedia. There's another word, which means you learn as you sleep, but there was not that. So I have the tape here and then I listen. That's why I like conference so much. And actually I'm following the online, I'm full of that. Last week, we had the conference accounting and finance. I followed online, and I was at Democritus, and I followed on site another conference. It's amazing, the technology, and I like it. And one day I hope that we'll get rid of judges, lawyers, because AI will do all the work. They will save the planet. And there will be